Ladies and gentlemen, you must be wondering what on earth you have to do to get rid of me. Some of you will remember that I jumped before I was pushed over a year ago, having, I think, been in post for about 15 years. And ever since then, my successor has found reasons for not turning up. It's very difficult to fill Nigel Fleming's shoes, but I think he's the living proof of the rule that you only appoint somebody to do a job who's too busy to do it. Nigel's apologies for tonight are that he is appearing in a matter which even he regards as difficult. That says quite a lot for it. In what we used to call the House of Lords, before someone came up with the bright idea of abolishing it. Never mind, it'll all drop into place later. But if I was going to come back to introduce just one more president, there is nobody whom I would rather do that for. It's a huge honour to introduce tonight's president to you, Mr. Bentham, and ladies and gentlemen. And looking around, never before have we attracted quite so many distinguished people in this theatre. It's a huge tribute to him. And I'm very grateful. Welcome to you all for coming. Charlie and I were professional neighbours in Essex Street for nearly 15 years. Both our careers, insofar as I ever had one, both our serious jobs came to an end in 1998. Mine rather more ignominiously than his. I unwisely believed what the Cabinet Office told me about the length that the bloody Sunday inquiry was going to take. He evidently believed them in what they told him about New Labour, in that it was going to be new and have something to do with the Labour Party, and he apparently believed that as well, which says more about him. The only difference between this is that I of course, went off and sulked for about 15 years. He set about abolishing his own job, and in the process of succeeding in tearing up an unwritten constitution, which is something of which, Mr. Bentham, I think you would approve, but some of us had slight doubts about. And if anybody's going to explain it to it's he, and I look forward hugely to that. It is with huge personal pleasure. He is a man who, as a friend and as a colleague, I admire enormously, more than I admired him as a politician, but that's because I understand nothing about politics, and he's going to explain why I got it all wrong. But it's a very sincere welcome to you, Charlie. Thank you very, very much for coming.
Mr. Bentham, Edwin, thank you for that very, very kind introduction. I was thinking, as you were speaking, that I left to go to politics, you left to go to the bloody Sunday inquiry. As you say, I ripped up a small part of an unwritten constitution, and you were responsible in part for what will be one of the most brilliant reports about a historical incident which will never be beaten in terms of it being a record of what happened. So I suspect you came out better of the story than I did. Thank you as well for inviting me to be the president of the Bentham Association. I am genuinely honoured to be the president. Edwin told me when he was coming up the stairs that every single Master of the Rolls since 1945 has been the president of this society. I'm glad to see two of the Masters of the Rolls here. I was wondering who the one Master of the Rolls since 1945 was who had not been asked to be the president of the Bentham Association. I assume it's somebody who's only the Master of the Rolls for a very short time indeed. I want to make the case today for the role of the modern Lord Chancellor as the protector of the rule of law and the independence of the judiciary within the executive. The Constitutional Reform Act 2005, I believe, was necessary to ensure that the role of the Lord Chancellor was suitable for a 21st century democracy. But now that the role has been reformed, I wonder if everybody has appreciated key provisions within the Act that enshrine unique and special constitutional features, and in particular, the fact that the Lord Chancellor's function has not diminished in his responsibility for protecting the rule of law within the executive. His or her role requires a deep understanding of and respect towards the rule of law, an appreciation of the need to stand up for judicial independence within government, an ability to build a strong and two-way communicative relationship with the judiciary, and the strength to act above party politics and beyond collective responsibility as the Act allows. The Constitutional Reform Act does not take away those functions from the office of Lord Chancellor. Indeed, if properly interpreted, it only serves to emphasise them and also to put them on an unconflicted footing, which was the position before the Constitutional Reform Act 2005. The office of Lord Chancellor to this day still ranks higher than the Prime Minister as an office of state in the order of precedence. Whilst I was Lord Chancellor, I was disappointed to discover that the Prime Minister didn't seem to realise the fact that I rated above him in the order of precedence. It's an office with a long and unique history. Like so many of our constitutional characters, the role has been difficult to define. Historians differ on the exact origins of the title and role, but most seem to trace the inception to the post-Norman conquest period. Ecclesiastical figures, as the only men of real education, they in Norman times took the form of spiritual advisors to the king. But it was their administrative function as custodians of the king's seal that saw the role develop alongside the growth of the machinery of early government. The royal seal was required for the authorisation of writs, and thus much of governmental business required the Lord Chancellor's stamp of approval. As Tudor kings fought wars abroad, the role was enlarged further, as the Lord Chancellor, I'm happy to tell you, would often be left to run the country. The office of Lord Chancellor arguably reached its zenith during this period, when the all-powerful Cardinal Wolsey was described by chroniclers as Alter Rex, the other king, when Henry VIII was preoccupied by his adventures in France. The continued growth in the Lord Chancellor's administrative functions was accompanied by a developing role of the judiciary. He would advise the King's Council, draw up writs for actions in the King's courts, and began to petition the King himself on behalf of citizens unhappy at the remedy they had received in common law. He also became involved in disputes concerning trusts in relation to land, stepping in the name of equity and good conscience to resolve matters such as that. The result was the Court of Chancery, which was established as a court of equity, a position which lasted until 1875. The 20th century saw the role's scope increase rapidly to the point that by 2003, when I became Lord Chancellor, it was a dazzling amalgamation of titles, duties, roles, right across the executive, the legislature, and the judiciary. For example, in relation to the judiciary, I was the only member of the judiciary who was a member of every single division in the High Court and every single tier in the High Court and in every single court below that as well. The Lord Chancellor was also a party politician and cabinet minister, a judge, as I've described, the chairman of the Appellate Committee of the House of Lords and the Judicial Committee of the Privy Council, head of the judiciary, responsible either directly or by making recommendations for almost all of the judicial appointments in the country, and he was also a member of the cabinet and head of a large department. The administrative functions included criminal legal aid, the administration of tribunals and constitutional affairs, and the role in administrative terms had grown in scope in the immediate years prior to my taking office, due in large part to the activities of my immediate predecessors. The Lord Chancellor's role was not always confined to those areas for which he had direct responsibility. Upon taking office, for example, my predecessor became the chair of the Cabinet subcommittees on devolution, freedom of information, the incorporation of the European Convention of Human Rights, and subsequently the reform of the House of Lords. In addition to all of those roles, the Lord Chancellor was also the Speaker of the House of Lords, albeit a Speaker who was habitually whipped by his own political party. He was also responsible for the Great Seal of the realm, as well as the Land Registry, the official receiver, the public records, and he was the visitor to 67 universities in this country. This great list of powers and responsibilities spreading across the three branches of the state, the executive, the legislature, and the judiciary, was a clear and obvious affront to the principle of the separation of powers. It has long been recognised that our Constitution, though uncodified, reveres this principle. To avoid arbitrary decision-making, the three branches of the state must be kept largely distinct in terms of personnel and functions. Lord Diplock said, "It cannot be too strongly emphasised that the United Kingdom Constitution is firmly based on the separation of powers." In this context, to have the role of Lord Chancellor spread across all three branches of the state was increasingly absurd. To spend the mornings as an unelected cabinet minister making decisions of real political importance and then making decisions related to the make-up and appointments of our judiciary seemed an aberration to all concepts of modern democracy. As one of my successors, Ken Clarke, put it, if a dictatorship abroad had such a role, we'd be up in arms about it. It also put the Lord Chancellor in difficult constitutional positions. Austin Mitchell, MP, said on the Lord Chancellor's varied roles, they could, he said, perhaps be performed by the Almighty, but it is something of a difficult model for a mere mortal, which I understand the Lord Chancellor to be. These difficulties, which have developed over a long period of time, were further exacerbated by the legitimate and developing constitutional nature of the judiciary and the courts. The 20th century, as we all know, saw the dramatic increase in judicial review as the state's powers grew in the post-World War II settlement. The development of European Union law has often meant the judiciary are involved in making politically unpopular decisions. This has been compounded with the implementation of the Human Rights Act 1998, a foretaste of the increasing scrutiny on judicial independence emerged in the Pinochet cases in 1998 and 1999, where the disclosure of Lord Hoffman's interest in Amnesty International resulted in the House of Lords setting aside its own decision. It was in this period that it became increasingly clear that the judiciary's increasing role in policing and setting the limits of state action would prove problematic for the Lord Chancellor. By the time I came to the office in 2003, in the aftermath of 9/11 and in the midst of the war on terror, the courts were only going to be put increasingly in difficult and delicate situations. The courts and the judiciary, over a period of 50 years, have developed a much more central place in our Constitution in the sense that they set limits for executive action, which they had not been doing in the period prior to the Second World War, or indeed in the period immediately after it. The judiciary were and are required to police the boundaries of executive power and determine sensitive human rights issues. With the executive increasingly finding their measures and actions subject to review in the courts, the failure to have a distinct separation between the executive and the judiciary was and is, or was, an increasing concern. The role of the Lord Chancellor as head of the judiciary and a member of the executive was no longer tenable. There was a distinct danger of the office constitutionally unravelling under pressure of modern phenomenon the role was unaccustomed to handling. I believe the time had come for change by the time the Constitutional Reform Act 2005 was passed. The Act transformed the role, in effect. The Act provided for the Lord Chief Justice, the President of the Courts of England and Wales to head the judiciary, and the Lord Chancellor's title subsequently encompassed the new role of the Secretary of State for Justice. The Lord Chancellor was also replaced as the presiding officer in the Lords by the new Lord Speaker. The Act also created a new Supreme Court without the Lord Chancellor's involvement, taking the highest court in the land from under the legislative shadow in the House of Lords across Parliament Square to a place that now exemplifies its independence from Parliament and its independence from the executive. Its new buildings offer real symbolic importance as well as institutional independence. The Supreme Court is now completely outside the auspices of Parliament, but continues to be in close quarters, as it should, scrutinising the action of the legislature and the executive. The Constitutional Reform Act also created a new independent appointments process. It was surely one of the most obvious aberrations to have a politically appointed member of the Cabinet making judicial appointments. Now the Judicial Appointments Committee has primary responsibility for appointments, ensuring independence. The Act also reinforced security of tenure. Senior judges hold office for as long as they wish. It would take a vote from both Houses of Parliament and the assent of the monarch for the dismissal of a High Court judge. The Act also provides for salaries to be determined by an independent body. All these measures were designed to ensure the separation between the executive and the judiciary and to reinforce judicial independence. These reforms were necessary and right. However, there was a real benefit to the pre-reform Lord Chancellor. The breadth of the role spread across the executive, legislature and judiciary meant the office holder had an ability to make strong representations within government on behalf of the judiciary. Lord Hailsham was an advocate of the advantages of the tripartite function. He said, unlike the Holy Trinity, the Lord Chancellor is only one person, and because he is only one person discharging various functions, he is the only practical guarantor of the independence of the judiciary from political interference. His point was well made. For all the democratic problems with the tripartite Lord Chancellor, the political aspect of the role certainly meant that the judiciary could defend its constitutional corner without having to engage itself directly. The multi-function role had practical advantages. Lord Mackay, Lord Chancellor from 1987 to 1997, often commented on the benefits to the judges of having a considerable political figure making the case for the financing of the courts on behalf of the judiciary. This prevented a situation where the judges themselves had to bang on political doors asking for money, as in the United States of America. There is absolutely no doubt that many pre-reform Lord Chancellors were figures of very considerable weight, ensuring the judiciary had a voice around the cabinet table. Lord Mackay was, according to Ken Clarke MP, one of the most respected members of the Thatcher government. Lord Irvine was certainly not a character who many in the cabinet would ignore. His style contrasted with Lord Mackay's quiet authority. It did not lack authority for that. I remember Baroness Smith, the wife of the late Labour leader John Smith, claiming that whilst Mackay was a noiseless politician, Irvine was more noisy than that. For all of Lord Irvine's noise, he never lost the respect of colleagues due to his remarkable technical and intellectual gifts. With different styles, both undoubtedly understood the role of Lord Chancellor in standing up to executive power when necessary in aid of the rule of law. When the Constitutional Reform Act was going through Parliament, there were concerns that this function and this role would be lost. There was a distinct danger that the robust Lord Chancellor of old, who stood apart from Cabinet with a responsibility for standing up for the rule of law, would become a diminished figure. With the new role as Secretary of State for Justice, with wide-ranging departmental and budgetary responsibilities, some feared the new Lord Chancellor would be just another member of the Cabinet, focused on public service delivery, oblivious to the constitutional significance of the office. The argument was a rational one. By reinforcing the separation between judiciary and executive, you inevitably increase the disconnect between the two. This was a dangerous interpretation of the effect of the Act. The judges are, in one sense, the weakest part of the Constitution and cannot defend themselves. They are vulnerable to the populist whims of the elected government, but must always stay mute. At the same time as breaking the Lord Chancellor's link as the head of the judiciary and a member of the Cabinet, there was an anxiety that this would only perpetuate the longer-term trend as well of mutual misunderstanding between executive and Parliament on the one hand and the judiciary on the other. There are fewer and fewer MPs who have practiced law for significant periods in government, and there is only one High Court judge, who I'm happy to see here today, who has ever been a Member of Parliament. This only increases the divergence in attitude and perspective. Whilst the Constitutional Reform Act allows the Lord Chief Justice to make written representations to Parliament on important matters relating to the judiciary or the administration of justice and appear in front of relevant select committees, these actions inevitably lose their currency if they are used often. In any case, the Lord Chief Justice is not able and should not have to survey the entire government programme for potential deviations in executive power. So there was a potential vacuum within the executive where previously there had been a loud and powerful voice defending the rule of law and defending the independence of the justice. What I fear has all too often been overlooked is the express and clear provisions within the Constitutional Reform Act to retain and entrench the role of Lord Chancellor as the defender of the rule of law and indeed the justice system as a whole. Section 1 of the Act states clearly that the changes do not adversely affect the existing constitutional principle of the rule of law or the Lord Chancellor's existing constitutional role in relation to that principle. The historic role that Lord Hailsham, Lord Mackay and Lord Irvine and many of those before them so clearly understood was and remains untouched. Section 2 of the Act sets out particular characteristics that the Prime Minister should consider when choosing a Lord Chancellor. By its inclusion alone, this unique provision in the Act, which is unique in relation to any member of the Cabinet, strongly suggests that a special quality and therefore a special freedom is both required and given to the Lord Chancellor. The list of factors the Prime Minister is to take into account in appointing the Lord Chancellor repeats the requirement of experience. This suggests a figure of authority with experience in Parliament or as a practising lawyer or a legal academic. Section 2's repeated preference towards experience also suggests a figure who is towards the end of their career, without ambition and able to act beyond party politics and their own personal aspirations. The ability to act above party politics and beyond collective responsibility, untrammelled by collective responsibility, is of critical importance to the role of Lord Chancellor. Section 17 of the Act sets out the oath that the Lord Chancellor is required to take by statute to, quote, respect the rule of law, defend the independence of the judiciary, and discharge my duty to ensure the provision of resources for the efficient and effective support of the courts for which I am responsible. It is very difficult to read the oath set out in Section 17 of the Constitutional Reform Act and then declare the modern Lord Chancellor to have no constitutional role as protector of the rule of law within the executive. It is clear as well on close inspection of the Constitutional Reform Act that Parliament expressly envisaged the Lord Chancellor being a departmental minister, true, with all the clout that that brings politically, but with special added responsibilities for the rule of law and for the protection of the judges, and special qualities individually. The essence of these sections of the Constitutional Reform Act is a requirement of the office holder to understand and have the ability and willingness to stand up for the law and the judges. Firstly, this means making sure that the judges are properly protected. This means ensuring that negotiations about their terms and conditions are undertaken away from the public glare, but with an appreciation of their independence and their inability properly to argue publicly on their own behalf. Critically as well, judges should be protected from attacks made by the government, and they should be free from any pressure which comes either from their terms and conditions or by views expressed publicly by the government. Secondly, the Lord Chancellor, in accordance with the terms of the Act, has a special responsibility within government to ensure that the state complies with the law in both a domestic and international context. This includes a willingness and ability to speak out when the office holder feels that there is not compliance with the law. Thirdly, as the express terms of the oath in section 17 make clear, it involves ensuring that there is a functioning justice system that means people's legal rights can be effectively vindicated, and that people, however rich or poor, however popular or unpopular, have access to justice. To many here, these points will all seem straightforward and obvious. But within government, with daily political pressures and firefighting that can occur, the importance of these constitutional provisions can get forgotten. It is critical that the Lord Chancellor is a restraining voice that protects all aspects of the justice system. Judicial independence is a vital element of the justice system, and it is critical to the UK's unwritten constitution. To a large extent, this part of the Lord Chancellor's role is uncontested, but opinions about the extent of this responsibility do differ. Lord Hailsham argued that all Lord Chancellors should be measured by their success in defending and preserving judicial independence, such that, and I quote, "If he does it well, he is a good Lord Chancellor, whatever else his other defects may be. If he doesn't do it well, whatever his other qualities, he is not." This verdict differs from that of the current office holder. That wasn't intended to be a joke. During his evidence to the Lords Constitution Committee, he said that if a colleague in government had described a judge's decisions as, quote, bloody stupid or idiotic, he, quote, may take them to one side for a quiet word. I believe a Lord Chancellor needs to be more robust. This includes taking public positions, chiding colleagues, and defending the judiciary's independence. I remember Ken Clarke, in his spell as Lord Chancellor in the early years of this current Parliament, taking an admirable and clear stance when Theresa May claimed in a speech that a judge had refused to deport an applicant because they were, quote, too emotionally close to their cat. Of course, immediately Ken Clarke knew this statement was absurd and sought to correct it. With typical style, Ken spent the rest of the day telling as many journalists as he could that the story was, quote, bonkers. He would have immediately known that May's suggestion was likely to have derived from an overeager speechwriter lifting stories from the Daily Mail. And he was right. The Bolivian man to whom the Home Secretary was referring was given leave to remain in the United Kingdom because the judge had found that the Home Office had not followed its own rules and that the man had a serious and long-term relationship with a UK national which justified him staying in this country. The cat, as it happened, was not a factor in the decision. Taking public positions supporting the judiciary when necessary is a critical part of the role. The Lord Chancellor must also ensure the judiciary has a voice within government which protects their position. This is always a sensitive task. The government, especially in the current climate, are understandably looking for efficiencies and to ensure taxpayers' expenditure is dealt with frugally. Indeed, in the past, Lord Chancellors, including Lord Mackay and Lord Hailsham, have had tense discussions over pay and conditions with the judiciary. Even so, they always dealt with the situation with a degree of authority and a sense that they understood the position the judges were in. As Lord Mackay put it himself, the Lord Chancellor must provide a voice for judges whilst at the same time ensuring that they are not placed in a direct and probably inappropriate relationship with the executive. Again, this approach has not been entirely adopted by the current office holder. In entering negotiations with the judiciary over recent changes to the pension settlement, the current office holder made no secret of his wish to, quote, draw blood, the phrase reported by a Ministry of Justice source to the Times. The Lord Chancellor should be attempting to build a mature relationship with the judiciary. The current breakdown is deeply disappointing and worrying for the Constitution. A constructive relationship between the judiciary and executive also requires the Lord Chancellor to understand that judges should be treated by the state in ways in which ensures their independence and their personal position is respected. This means the judiciary should be allowed to run their own courts with a recognition of their special constitutional status within the public sector. In particular, where there are significant changes in the way in which judicial business is conducted, judges themselves must both lead such reforms and take responsibility for such reforms. This is because it is inappropriate and wrong for the executive to order the judges how to conduct judicial proceedings. Not only does it offend the independence of the judiciary, but the executive regularly lacks the expertise required to bring about effective reform. Even more importantly, only when reform of court procedures is judge-led will the changes stand the test of time. It is only with judicial leadership that the process has the required independence which gives it the required legitimacy. In the mid-1990s, Lord Mackay asked Lord Woolf to report on options to consolidate the existing rules of civil procedure. The reforms were able to transform civil justice with a legitimacy and independence that has ensured longevity. Whatever view you take about the reforms, there is no doubt that they were effectively introduced. In recent years, we have seen Sir James Mumby, who is here today, the President of the Family Division, lead reforms to family justice procedures, ensuring the creation of a new single family court and cutting the time within which public law children cases are dealt with to within a 26-week deadline. These impressive reforms, although in part reflected in legislation, were judge-led and have been again effective in their institution, effective because they had the buy-in of the judges. With depleted levels of legal aid, which are unlikely to be significantly restored, criminal cases need to operate more efficiently. While the state plays a role in prosecuting defendants and in the management of the police, changes to the criminal justice system in the sense of what happens in court are best led by judges that run the trials in their courts each day. The Lord Chancellor should be working constructively to give the judiciary the space to lead such reforms. While supporting the judiciary in undertaking their constitutional function, the Lord Chancellor as well has a key role within government to ensure the state itself does not circumvent the law. The current office holder has said, quote, "The task of upholding the rule of law is not something that simply resides with the Lord Chancellor, it is something that resides with every government minister." That's correct. Each minister should ensure their policies and their department's activities never contradict the rule of law. But the Lord Chancellor, by taking an oath to protect the rule of law, has a special responsibility. There is an imposition by the statute of a duty on him above and beyond that which is expected of any other government minister. That does not mean having to act as a sleuth, looking for potential deviations by snooping from department to department, but it does mean having an added awareness for the potential for illegality and a willingness to stand out against it. It requires making one's voice heard on issues across government at cabinet and being a person both of authority and integrity, such that if the government ignored the warnings of the Lord Chancellor would be forced to resign. Collective responsibility cannot and does not apply to the Lord Chancellor on issues of illegality or breaches to the rule of law. And defending the rule of law also includes ensuring the government is providing access to justice. The Lord Chancellor has a particular duty to ensure this with control of the relevant Justice Department. Access to justice requires sufficient funding of legal aid. Where there are examples of citizens being let down because of a lack of funding, the Lord Chancellor must, within government, be an advocate for sufficient provision within government. Clearly, this also includes an appreciation of the importance of ensuring that the judges remain able to set the limits of legality and illegality in the executive. This is a delicate balance to be struck for the Lord Chancellor. He or she cannot merely act as a lobbyist for the legal sector. Public policy may require cuts and efficiencies to spending in the courts and on legal aid. Sometimes lawyers can underestimate the incredibly difficult dilemmas and considerations government ministers have to make when prioritising areas of spending. The courts can't simply stand back and watch the rest of the public service tightening their belts. But in attempting to strike this balance, it's critical the Lord Chancellor has built a constructive and working relationship with the judiciary. Lord Lane, the Lord Chief Justice for much of the Thatcher government, campaigned vigorously against various of the government's plans, including the government's plans to abolish some of the legal profession's restrictive practices in the 1980s. He famously said, in response to the proposition that solicitors should have rights of audience in the higher court, that oppression does not stand on the doorstep with a toothbrush moustache and a swastika armband. It creeps up insidiously, step by step, until all of a sudden the unfortunate citizens realise freedom has gone. Characteristically brilliant rhetoric, if slightly over the top, considering the government's relatively modest proposals for reform. The problem that the Lord Chancellor always faces is that the lawyers and the judges all too readily say that a particular form is going to bring justice to an end as we know it. The Lord Chancellor is therefore faced regularly with a difficult decision as to when to speak out and say, in the context of the new constitutional settlement, whether his oath would be broken if he agreed to a particular cut or a particular change in the law, for example, reducing the rights of judicial review. He's got to make that decision. His decision would be easier if he had a close relationship with the judiciary and the rhetoric of lawyers and judges from time to time was able to draw a distinction between those provisions that really did undermine the system of justice as we know it and those which might be described as simply expenditure issues. The role of the Lord Chancellor is not simply to act as a respected arbitrator between a clashing executive and judiciary. When the government is genuinely undermining the rule of the law, then there is no doubt that the office of the Lord Chancellor requires him to stand up for the rule of law and not for the government. On Monday of this week, the government sought to implement, I don't think it was Monday of this week actually, but on some day this week, the government sought to implement the Civil Proceedings and Family Proceedings Fees Amendment Order 2015. The effect of that order will raise the fees claimants must pay when starting court proceedings. This is before any lawyer's fees. Of the fees to the court will go up by 600%. A small business who may be chasing debts fundamental to their prospects over the coming years will have to consider seriously whether litigation is affordable. If your claim is for £40,000, you will see fees increase by 228%, as Lord Panic, who I'm glad to see here, has so powerfully argued in this, the 800th anniversary of Magna Carta, which prohibited the selling of justice. It would seem exercising one's legal rights is increasingly becoming the preserve of the very rich. I believe that although one has to be incredibly guarded as the Lord Chancellor in playing one's ace card, a more robust Lord Chancellor should be opposing such measures. And indeed, the amounts of money that will be raised could not possibly justify the increase in fees that are being proposed and which will have a very fundamental effect on access to justice. There is a statutory provision for this in the Constitutional Reform Act, as well as Section 92 of the Courts Act 2003, that ensures the Lord Chancellor has regard to the principle that access to the courts must not be denied. It is a provision which, having regard to the constitutional settlement that has been made, the Lord Chancellor could have stopped within government, simply by indicating that he would have taken the view that his oath would have been broken and there would have been no requirement for it ever to see the light of day. The office of Lord Chancellor, for the reasons I've indicated, requires a figure with particular and special characteristics. As I have said, Section 2 of the Constitutional Reform Act sets out a number of criteria, but rightly allows the Prime Minister room to manoeuvre, which is entirely correct. The Prime Minister should have very considerable freedom as to who he makes Lord Chancellor. It includes a provision to allow the Prime Minister to consider, and I quote, any person with, quote, other experience that they, the Prime Minister, consider relevant. It's a matter of some debate as to whether this section was drafted too widely. In hindsight, the legislation may have been more prescriptive in setting out the desired qualities. It could have been more qualitative rather than merely emphasising experience in different fields, understanding of the Constitution, understanding of the rule of law, a willingness to stand up against party political consideration, an ability to act separately from collective responsibility. Each could have been explicitly added to the legislation, although the drafting of such characteristics might have proven difficult. Even as it stands, it is clear that Section 2 sends a strong signal about Parliament's desire for the Prime Minister not to appoint somebody without the necessary qualities. It makes it clear that special requirements are needed. This is not just another cabinet post. It requires a figure who understands the rule of law in a way that is broader than an A-level textbook. Some have argued that it should be mandatory for the Lord Chancellor to hold legal qualifications. I don't agree that is a necessary prerequisite. The relative paucity of lawyers in the House of Commons would limit the scope. It is possible to identify people in the House of Commons or the House of Lords who are not lawyers, who would be much better Lord Chancellors than many of those who are. The combined role of Justice Secretary and the Lord Chancellor means to restrict the role to just lawyers would limit entrance to a major financial government department as well. I do, however, find myself disagreeing once again with the present Lord Chancellor, who sees, and I quote, a positive benefit for the Lord Chancellor not to be a lawyer. There clearly are significant benefits in the office holder having legal training. The legal system can best be defended by somebody who understands the system and understands the Constitution. A deep reverence and appreciation of the law and the rule of law, embedded through training and practice, would only embolden the office holder. But perhaps more importantly than a legal background, the position requires an individual with personal qualities that means they will actually stand up and be counted when the crisis comes for the rule of law and act beyond the considerations of short-term political advantage. This requires more than anything else substance and authority. It will from time to time involve damaging your relations with the Prime Minister and with others in the Cabinet, which will inevitably have consequences for one's career. To be heard in government but without the ambition to need consistently to please the Prime Minister. My two successors, Jack Straw and Ken Clarke, fulfilled that role with aplomb and to a T in the best spirit of the Constitutional Reform Act 2005. Finally, when the current Lord Chancellor told the House of Lords Constitution Committee that, quote, the constitutional role of the Lord Chancellor's department has moved to the Cabinet Office, and that the constitutional role that the Lord Chancellor once performed in a very practical sense is not currently there, end quotes, he seems to have completely overlooked the provisions in the Constitutional Reform Act I have just referred to. The danger of this misinterpretation is that the executive lacks a voice standing up for the judiciary and the rule of law. This will create increasing constitutional tension and difficulties between the executive and the judges in the future. 10 years on from the Constitutional Reform Act 2005, it's time to return to look at the statute and to remind oneself of Parliament's intention. There was no intention to weaken the constitutional importance of the Lord Chancellor. The Act expressly provides for the Lord Chancellor's constitutional role as the protector of the rule of law. I very much hope that future Lord Chancellors appreciate this statutory duty and the continuation of their historic role, and in the best traditions of the office, continue to act as a protector and advocate for the rule of law within the government. It was Thomas More, the Lord Chancellor, who stood up to Henry VIII and opposed the break from the papacy, who uttered the famous lines as he faced the Executioners Act, "I die the King's good servant, but God's first." If you replace God with the word law, you understand the role of the Lord's Chancellor. That spirit should ring true today. The Lord Chancellor must serve the government, but he must also be willing to defy it in defence of the rule of law. Thank you very much.
Ladies and gentlemen, Mr. Bentham, you can see what a reception that tour de force got. Nobody, Mr. Bentham, would have enjoyed it or respected it more than you. I recall, I haven't got it with me, but I treasure the collected book of his letters, which somebody very kindly gave me when I took on this job, in one of which he wrote to his nephew, one of his nephews from Edinburgh, expressing his disapproval of the way in which one of the few pieces of legislation which he approved of was being actually carried out, in citing his favourite poet, Alexander Pope, in saying that it didn't really matter what the legislation said because the forms of government let fools contest, whatever is best administered is best. I think he would have particularly enjoyed what Lord Falconer said tonight. And the fact that it is said in the presence of so many, not only of our distinguished past presidents, but of distinguished the judges on whom we most respect and whom we most admire, present, including our own Lord Chief Justice here tonight. And now I be forgiven for making one other tribute before passing over, because Lord Falconer has very kindly agreed to take questions. It is particularly warming that an address like that, in this institution of all places, should be in the presence of the Emeritus Attorney General, yet another man who put principle before party and retains the respect. As you can see, Dominic, you are particularly welcome in this institution tonight, treated with the respect and affection of all members of this profession, which you have always so richly earned. Lord Falconer has agreed to take questions. Please feel free. It's the one opportunity you'll get. Everybody's going to be far too terrified to say anything. Follow that. Yes.
Is there such a person who reaches a point in the law where they have no ambition?
Is there such a person?
Who, in the law, who reaches a point where they have no ambition?
I think, no, I've never met somebody in the law at such a point, but the point that I was making is that if you are in the executive and you have no ambition within the executive, whilst you may have the strongest possible ambition to be respected by the outside world and maybe have a career outside the executive, you will be willing to stand up to the Prime Minister and you will not seek the approval of your party, which are two huge motivators within government, and the people who hold ministerial office are almost invariably thinking about their next job rather than the current job. And the key to the holding of the job, I think, is somebody who is thinking, I've really got to do well in relation to this job. And I do want to emphasise strongly that I do not think that it necessarily requires for there to be a lawyer. There are politicians, and I think of people like Roy Jenkins, Merlin Rees, Willie Whitelaw, William Hague, people such as that, who would probably make excellent Lord Chancellors at particular points in their career, because they understand the Constitution and have a profound desire to make government work. They would also be incredibly effective advocates within government, because they know how government works, to get as good a financial settlement as possible for the court system and the prison system as well.
David.
As you mentioned the new fees
Yeah.
on access to court, and you were rightly critical, of course.
Yeah.
Would you like to comment on the failure of the Labour Party, either in the House of Commons or in the House of Lords, to agree to vote against that new order?
Well, it's incredibly disappointing because the effect, obviously, I mean, I heard you on the radio, David, I was completely persuaded, but if the Labour Party won't support you in the House of Lords, and the consequence is that you won't win in relation to stopping it. Partly, I suspect the reason it's understandable is that we're in an era where we're heading for a general election, and therefore to be seen to be, inverted commas, sensible on expenditure cuts and cost increases is a necessary part of what happens at this particular sort of period. Otherwise, I completely endorse my party's policy in every single respect.
If it would help, David, I will undertake to make copies of the speech tonight available to you to distribute among your friends and your enemies. Any more? In that case, sorry. Joe.
The practice of government ministers criticising judicial decisions which they thought to be adverse seemed to increase pretty exponentially under the Blair government, and one needs only to think of certain Home Secretaries. Could you explain to us how you put into practice the role that you've explained that Lords Chancellors should play in that situation?
I disagree with the fact that it raised exponentially under the Blair government. If you look at the history of this, it's sort of happened all the time. I don't know if you remember a man called Michael Howard. He used to criticise the judicial decisions all the time. Nicholas Phillips was the Lord Chief Justice, and I was the Lord Chancellor. The biggest example of it, which had occurred when I was Lord Chief Justice, was the most excellent recorder of Cardiff. There was an absolutely horrific crime of a man who had sexually assaulted a child, had driven a car away with the child in the car, had pushed the child from the car, and had millions of previous convictions of a similar sort. This all happened in a halfway house, because he'd just been released whilst the subject of every single sort of probation, suspended sentence, etc. The Recorder of Cardiff sentenced him to the absolute maximum available to him on every single ground. I think the Home Secretary of the day, Mr. John Reid, Dr. John Reid, criticised the judge for not giving him enough. I can't think, the judge couldn't do anything more. I spoke to Dr. Reid, and I explained to him that there was a bit of a misunderstanding here. Dr. Reid accepted there was a misunderstanding, but did not make public that he thought there was a misunderstanding. That happened on the Monday. The fuss got worse and worse and worse, and eventually on the Thursday, I said that it was entirely not the judge's fault. It was entirely the fault of the politicians, because they had passed the Act of Parliament that had led to this being the maximum that was available, and the sort of fuss then went away and duly fell upon the politicians. The Recorder of Cardiff, I should say, a fantastic person called Mr. John Griffith-Williams, Mr. Justice Griffith-Williams as he is now, was totally easy about the whole thing, in the sense that he did not, I mean, he was strong, rather unaffected by it, thought it came with the territory. I thought he was a bit over-robust in relation to the whole thing, but he treated it with real maturity. I don't think you're ever going to get away from that sort of attack by politicians. I think it is important, though, that there is a sense that there is somebody in government who will do something about it, and if nothing happens, say something about it publicly. I don't think it's going to stop it in the future, but I think it's important there's somebody there with authority. I think that I was too slow in responding, because I think the attack started on Monday, and I didn't respond until Thursday. But there was somebody there who ultimately spoke about Griffith-Williams' position, and I acted throughout, closely talking to the judiciary, and indeed I spoke to the Lord Chief Justice, and I spoke to Mr. Justice, or His Honour Judge Griffith-Williams, as he then was, who would have been perfectly happy for me to say not a word. I think that's all you can do.
Do you think the Lord Chancellor should advise the government to comply with decisions of the European Court of Human Rights?
I do. I most certainly do. I said in my remarks that the obligation of the Lord Chancellor was to but seek to ensure compliance with the provisions of law, both domestic and international, and compliance with the European Court of Human Rights is a requirement in international law terms of the British government, and so they should comply with the requirements. And if we're not willing to comply with the requirements of our international obligations, then we will have to change our international obligations or leave them.
On that note, may I thank Lord Falconer again on your behalf and suggest that we make him equally welcome over there.